So it is of utmost importance that India gains a reputation for enforcing the contract through legal process efficiently in terms of cost and in terms of time. We are right now much behind the Western world. Difficulty is really multifold.
Recently, Queen Mary did a survey on international arbitration. They do it every 4-5 years. First question was, what is the preferred seat globally? The winner was London, 34%. Then the runners-up was Singapore, 31%. Then it was Hong Kong, again at almost 31%. Then it was Beijing, somewhere around 20%. New Delhi is 20th in that list at 2%.
How do we educate the judiciary? Because I have heard this comment from somebody very senior in the judiciary as well, that there are judges who don't understand nuances of the subjects that they are dealing with. Hello there, welcome and good morning, good afternoon, good evening, depending on what time you're watching this podcast. Welcome back to Transforming India, the Road to 2047, presented by Mint in partnership with JSA Advocates and Solicitors. I am your host Alokesh Bhattacharyya. I am Deputy Managing Editor of Mint, your favorite newspaper. Now, with India's GDP projected to cross $7 trillion by 2030, the volume and complexity of commercial disputes will only rise. So, in that context, strengthening dispute resolution through arbitration hubs, mediation frameworks and judicial reforms, these will be extremely crucial to keep investor confidence in our economy and also for facilitating cross-border commerce. So, to explore this extremely critical subject, I am joined here by two leading legal experts with deep experience in high-stakes dispute resolution. And just to tell you, both of them have profiles that are as long as your arm, and you will be impressed. My eyes started glazing when I read through them. So, first we have Amar Gupta. Amar Gupta is the Joint Managing Partner at JSA, which is the top post, right? He has more than 3 decades of experience in dispute resolution as well as international arbitration. He advises clients on complex disputes, arbitration strategy, as well as regulatory issues. He has been instrumental in shaping India's arbitration landscape. Joining him is Divyam Agarwal. Divyam is partner at JSA. He specializes in dispute resolution and arbitration across some critical industries such as infrastructure, energy and construction. Divyam is a dual qualified Indian advocate as well as an English solicitor advocate who has represented clients in high value cross-border disputes. Welcome, and it's really a privilege for me to be speaking with both of you. I just hope you don't take me to court after this for asking you some questions when normally the reverse happens, right? So, let's start. You were here last year, right? In the
Yes.
last year's.
Yes.
What do you remember anything from last year? Anything that struck you?
Well, arbitration landscape was the topic of discussion, and we explored the development of arbitration and the regulatory reforms that has been done in arbitration.
Yeah. Very interesting, because just for your information, last year our partnership had tackled the issue of per capita income growth in our country, right? Because while we can justifiably hope to have a vision and a grand kind of target of becoming a developed country by 2047, it's really of no use unless the skew in the per capita income is addressed equitably. Because even today we have certain areas of India where the per capita income is as high as the highest parts of anywhere in Europe or the US, and some parts where the per capita income is very, very, very low, sub-Saharan levels, right? So, that inequity, unless we address, then the benefits of becoming a developed nation will not probably come through to the masses in a proper way, that living standards rise for everybody, right? Not like everybody becomes equal, but living standards rise commensurate with where they are today. So, that was something that we spoke about. You should check out last year's podcast as well as our roundtables. We had some really great discussions. Let's start with today's session, gentlemen. So, how about a quick rapid fire? We call it the rapid 5. Start with the first question to both of you: arbitration or litigation?
Arbitration always.
Arbitration always.
For complex disputes, arbitration. for any substantive question of law involving public importance than litigation.
Okay, so arbitration always and depending on the situation, and if it's more complex, it should be arbitration.
100%.
Yeah, I think there is some legal changes also, right, in terms of encouragement for arbitration from the government. And
Well, arbitration has certain limitations. There are certain issues which are not arbitrable. So there are Supreme Court rulings identifying the non-arbitrable category of disputes.
Right.
So those disputes cannot be referred to arbitration, and that's what Divyam referred to when he said that the disputes involving questions of public law cannot be referred. As regards encouraging arbitration is concerned, yes, various steps and measures have been taken by the government of the day, this and as well as the previous ones. This one the current government has been more proactive and more comprehensive in reforming the legal landscape for promoting arbitration.
arbitration is always a more preferred kind of thing, no? Instead of getting into fight and to the courts and all, just settle it amongst yourself, kind of thing.
It is more preferred. The ecosystem is such that it helps companies resolve their disputes outside of the rigmarole which is attached to any court litigation.
Yeah. Related to this discussion that we are having is the next quick 5 question, which is what is India's, you first, Divyam, what is India's biggest arbitration challenge currently?
Judicial intervention.
It is important for the stakeholders to adopt institutional arbitrations far more often than it is being adopted now. Ad hoc arbitration has not been very satisfactory in our jurisdiction, and it is important for success of arbitration to that the stakeholders adopt more and more institutional arbitrations.
But what about enforcement risk, right? High, medium or low?
I would say medium to high, and it also depends on which part of India you're trying to enforce.
So it differs by region.
Absolutely.
Also.
Yes.
What about you?
So again, concur with Divyam, medium to high. In certain some jurisdiction in India, the enforceability experience can be comparable to the best in the world.
Right.
It is the efficiency in terms of time and cost are comparable to more sophisticated jurisdictions in the world.
And which parts are these?
For example, Delhi.
Okay.
So if enforcement is brought in Delhi, it is likely, the timeline is likely to be comparable to anywhere in the world.
Good to know that since I live in Delhi, it's, although I hope never to get into any arbitration or litigation either way.
No, I can explain to you by an example. A client of mine is enforcing a UAE court decision simultaneously in Delhi and in London. And the timelines are, you'll be surprised, comparable.
Okay, so what's your preferred seat of arbitration? Both of you have been international lawyers, like you've been practicing everywhere. You're, like I said, your profile is, both of your profiles are the length of my arm, and you are in some international court of
ICC
law?
court of
ICC court of law.
Arbitration.
Yeah, yes. Arbitration and all that. So, okay, so what's your preferred seat of arbitration?
Singapore.
So Singapore and London, exactly same as is. Personally speaking, I would like to see Dubai also as a preferred seat. However, we don't share reciprocity at the moment, and therefore it is not being preferred.
There was some talk about India being an arbitration hub.
That talk has been going on for a long time. Some effective steps have been taken. Credit must be given where it's due. Government of the day has taken some effective steps. Court decisions have also been very supportive of arbitration process. But given the hierarchy of our court, there are courts pulling in different directions. So the message that is sent by the highest court of the land does not percolate down to the lower courts. So the approach of the lower courts tends to be lacking and unsupportive of arbitration, which is not consistent with the messaging that is delivered by the decisions made by the Supreme Court.
There is also a requirement that we should really, if we have to develop India as an arbitration hub, then we really need to improve our standard, our quality, are certainty of enforcement. In fact, I put it that there are 3 C's: certainty, consistency, and clarity.
Consistency, especially.
Yes.
Right. Different courts giving different verdicts on the similar kind of issue.
Correct. And certainty as well, because we have seen instances where arbitral award, after going for 6-7 years of challenges before the court, was set aside. So we have seen that experience also. So that does not bode well within institutional investor or a foreign investor, as they would like to see that once the arbitral award is passed, it sees in a shorter span of time, it sees light at the end of the tunnel.
Okay, one last quick 5 questions. One reform that dispute lawyers are eagerly awaiting.
Overhaul of the Arbitration Act.
I say, and which is possibly we are going in that direction of having emergency arbitrator, and it's a process that has been introduced in the arbitration bill. If that comes, I feel that would be a step in the right direction.
What change would you want in the Arbitration Act?
Provisions restricting courts' interference to be more to be strengthened by various amendments, and the institutional arbitration is mainstreamed by the statutory provisions.
So, what do you mean by institutional arbitration?
Well, arbitration is generally in India held privately, conducted privately by a private tribunal through a procedure which is evolved by the parties and the tribunal, private tribunal. It has been found that the arbitrations conducted by arbitration institutions tend to be much more efficient and much better administered, and in terms of timeline, much more efficient. The cost is predictable, and there are these international institutions which have established reputation for efficient conduct of arbitration. There are certain institutions, homegrown institutions also, which have come up in India. Mumbai Center of International Arbitration is one of them, and it is leading the march amongst the Indian institutions, and it has seen very good increase in the caseload.
You wanted to say something?
Yeah, no. Even the India International Arbitration Center that has got the blessings from the government, that is also developing fast. And just to add on that aspect, ad hoc is when we decide whatever we want to do.
Okay.
Institution is when the institutional rules determine how you're going to pace up, how you're going to proceed, and what is the process that's going to be followed.
Two salient difference between the two processes are the following. First, in case of institutional arbitration, the appointment is generally done by the institution itself. Even if the parties make the appointment, it is the appointment is subject to the approval and validation by the institution. And the second salient distinction is the applicable rules. In case of institutional arbitration, the arbitration procedure is conducted as per the rules of the institution, which are rules which have been framed by the institution after a great deal of deliberation and consultation. In case of ad hoc arbitration, the rules are evolved and designed by the arbitrator himself or the arbitration tribunal with the concurrence of the parties. And in case of ad hoc arbitration, the appointment is made privately by the parties or through the court if the procedure for appointment by the parties fails.
I'm quite amazed by the way you explain, even for somebody who knows nothing about law, it's becoming clear to me what you are saying. You will agree that, the quick 5 actually went on for longer than we had anticipated or planned, but it was worth it, right? There's a lot of good insight and I hope you enjoyed the conversation. While we move on now to the next part, which is the main questions. So in 2022, India was among the top 5 countries represented in Singapore International Arbitration Center cases. What recent trends are you seeing in high value commercial arbitration involving Indian entities?
I see a marked increase in preference for institutional arbitration in high stakes and complicated arbitration. The preference is currently in favor of international arbitration institutions, but I hope to see increasing the Indian parties, Indian litigants, increasingly choosing Indian institutions also for resolution their disputes. MCIA is actually getting some attention, and it is on the right path.
So institutional arbitration is gradually increasing here.
Yes, yes.
So which is a
yes,
good thing.
undoubtedly. Yes, of course.
Okay, so next one is to Divyam. India as an arbitration hub. So we spoke about arbitration hub a little while ago. So London, Singapore, Hong Kong, they are consistently ranking as the top global arbitration hubs. Just add a little more to what you were saying a little while ago about what it will take for India to join that league. Obviously, we are still not there, right? We need the consistency in delivering judgments and the 3 C's that you spoke of. Just give us a little more detail on that.
Just before going there, let me give you some statistics. Recently, Queen Mary did a survey along with White and Case and SOAS University. It was a survey on international arbitration. They do it every 4-5 years. First question was, what is the preferred seat globally? So the winner was London, 34%. Then the runners-up was Singapore at 31%. Then it was Hong Kong, again at almost 31%. Then it was Beijing at somewhere around 20%.
Really?
And New Delhi is 20th in that list at 2%. So
Beijing is a surprise.
Yeah, no, so it's not only Beijing. They have three Chinese provinces which are covered within the first 20. 3. So Beijing, Shanghai, and one more. So in New Delhi, the only Indian state that functions in that list is New Delhi. That is at 20th at 2% is what the numbers are. But while the numbers are stark, look at this fact that in 2021 we were not in that 20 list. So we are gradually moving up. So that's one point for consideration. Now let's look at what are the issues which we feel may be preventing us from becoming that arbitration hub, or what are the areas which needs improvement. First, we deliberated a lot right now is on the issue of enforceability, which ties into my point on certainty. Now, enforceability, if there is any foreign arbitration that's happening, and whenever we discuss this preferred seat, it's more looked into the parlance of international arbitration, and where there are parties. And when we talk about international arbitration, it means that one of the party is not from that jurisdiction, or maybe both are not from that jurisdiction. They can always have neutral seat of arbitration. Now, if you look at from that outsider or that foreign entity's position, and if they have made a lot of effort, expended a huge amount of money, and have gone through the entire process of arbitration, and they are holding an award, and suddenly that award either is not enforceable, or they faced some roadblock while enforcing the award, it gets stayed. All these issues will never bode well with any foreign investor or institutional investor. So that's point one. Point number two is lack of infrastructure, which is what Ammar pointed out on the institutional arbitration. We have been thriving only on ad hoc arbitration, which are determined on the case diaries of arbitrators, determined on the convenience of the parties. And I'm not only blaming the arbitrators, but even the councils. We are scheduling conferences and arbitral hearing at 4 p.m., 5 p.m. as per our convenience on a Saturday or a Sunday. So that mindset needs to be changed. We have to take arbitration, when we call it as an alternate dispute resolution, then we must treat it as an alternate dispute resolution. That's your point number 2. Point number 3 is the limited government support. You alluded to that point of government memo, and that was brought in May of last year, around that period of time, when the government indicated their preference and in some form and manner of disputes either to be resolved through mediation or through litigation. While there have been various conferences, seminars, and speeches where government has tried to dispel that particular notion. Ultimately, this memo has not received the approval from the highest of the authority, so it will be only treated as a memo. We will not give too much credence to it. But then it also needs to be seen from the actions of the government. Government also needs to demonstrate that for them as well, it is the most preferred form and manner. When you asked us what is our preference between arbitration and litigation, in a heartbeat we said arbitration.
Yeah.
That kind of a response needs to come from the government as well. So that's
Right.
my point number 3, which is more on the certainty. Now comes the aspect of clarity. The procedural rules and the Arbitration Act, there is a clarity which is required, and of course there have been various amendments. 2015 was a watershed moment for us. There have been some judicial precedents also supporting arbitration, but we need more clarity in our arbitration procedure. Imagine England also went through an overhaul in its Arbitration Act entirely just now. So why can't India, who has an act of 1996, can go through the similar kind of a procedure, knowing the fact that if we are supposed to act as an arbitration hub, then these changes are required to be made. And last point on the global perception. The global perception is that while India is improving and India is being considered seriously in this, and as the Queen Mary report suggests, we are now in top 20, but we need to show it from our actions. We need to show it from our judicial precedents. There was a recent decision on modification of an arbitral award, where it by 4:1 they indicated that in some instances an award can be modified. Now, what kind of a signal has that gone out is something one has to see over a period of time. But our objective and our exercise should always be that we favor arbitration and we further the objective which are enshrined in the Arbitration Act.
Right. This Queen Mary report, does it say how we managed to get into the top 20?
No, they
Doesn't
they
mention the
just did
factors.
they just did a survey of individual. Also, one aspect they mentioned that everyone, if they have surveyed somebody from India, then yes, their preference will always include India.
Yeah.
But let's say when somebody is sitting in UK and they are asking them the question, then India does not factor into their preferences.
Right.
So like we are right now sitting in India, we are seeing London and Singapore as a preferred seat. That kind of a mindset needs to be there globally, and that can only happen if we take some proactive measures.
And that's going to take time.
No, it will take time, and more than government initiative, I think the stakeholders need to reform themselves. As Divyam mentioned, that arbitration in our country is after our practice. So after we finish with our court and everything else, we go for arbitration hearing. So that needs to change. There is some initiative taken. There is a move towards constituting an arbitration bar, and I hope those kind of steps gain traction and become mainstream, then rather than the fringe developments.
Okay. Great. So we've been talking about arbitration, and we've discussed a fair bit about enforcement. But let's get into a little more detail about enforcement, right? Enforcement and courts. So, for example, the World Bank's Ease of Doing Business report once ranked India 163 on contract enforcements, and not too many countries after that exist. So, we're pretty much towards the bottom. Now, key Supreme Court rulings have strengthened the enforcement of arbitral awards, but court interventions, they still remain a concern. So, how do you see this, trajectory shaping investor confidence? We spoke about it a little bit, but investor confidence is so very critical. And enforcement, if something is, some verdict is taken in a Singapore tribunal, how is it enforceable in India? That is the core issue, if I'm not mistaken.
Yes,
right?
yes. So enforcement of contract and related to the enforcement of arbitral award, which is given by an arbitration tribunal to enforce the contract, is central to any investment decision that is made by international investors. So it is of utmost importance that India gains a reputation for enforcing the contract through legal process efficiently in terms of cost and in terms of time, both. We are right now much behind the world, the rest of the world, particularly the Western world, in that respect. And the difficulty is really multifold. One of the difficulty is that lack of sophistication and training amongst the judges in different parts of the country creates a lot of problem in being able. The courts are not able to understand the arbitration process and the importance of non-intervention and leaning in favor of the arbitration award. These are the key messages that Supreme Court sends out in every now and then, but those messages don't get percolated down. And the second problem is again the slowness of the court process riddled with procedure.
Yep.
Enforcement process is through the Civil Procedure Code, and that process itself can be cumbersome and tedious, and it may be very time consuming.
Look at from a perspective, and we did one matter where we went to a jurisdiction called Jharsuguda. Okay, it's an industrial town in Odisha, 350 kilometers away from Bhubaneswar.
Steel plants and all that.
This,
right?
Yes.
Yeah, it's a very thriving town. But imagine we are armed with an order, with an award passed by 3 retired Supreme Court judges. One of them is a Chief Justice, former Chief Justice of India. And we are going before a district court, district judge who may not have even, I mean, for lack of a better example, may not have stepped out of Jharsuguda. They don't understand and appreciate the nuances of a construction arbitration. Imagine the struggle we had explaining him the Emden rule, the Hudson rule, and explaining that it's an award passed by 3 former Supreme Court judges. So that kind of a struggle we are talking about. India is a vast jurisdiction. We need to appreciate that. We keep comparing ourselves with Singapore, but let's understand Singapore is as good as the size of Delhi. But when we talk about India as a nation, it's huge. So while keeping and appreciating those nuances around it, we also need to understand that not every, as he rightly points out, not every message is percolated down to the lowest level.
So, there are just going off script a little bit, just trying to understand, because one is the conveying of the message, right? Which I think happens in governance also. What is decided at top doesn't necessarily go down to the lowest level where it is implemented, right? I am hearing the same thing from you about the judiciary. The other thing also is about knowledge, right? Both in terms of these complex cases as well as in the area of technology, where things are moving so very fast, and all these net-based businesses and handling all these large companies and their complex transactions and complex ways of finding ways in loopholes, in various ways to boost revenue. How do we educate the judiciary? Because I have heard this comment from somebody very senior in the judiciary as well, that there are judges who don't understand nuances of the subjects that they are dealing with. What is being done in this regard, both in terms of training to understand these complex things, as well as arbitration, the complexities, as well as technology, and making sure that the pipeline is smooth and that the message goes through properly, so you don't have another example like Jharsuguda? Anything happening on that front?
You may be aware that India had established commercial courts, both in district court as well as commercial division in the High Court. It is of utmost importance that the judges who preside in these courts, who take charge of these courts, before their posting, they must be thoroughly trained in arbitration jurisprudence, international best practices, as well as the commercial laws and the latest developments in commercial laws. The arbitration cases generally in almost all states are converged in these courts. So once we are able to train those judges, bring them up to speed with the latest in terms of jurisprudence, as well as the practices and approaches in arbitration disputes. So I think we would have come a long way. So that's one major step that would that I would recommend. And in fact, it's quite easy to do it because there are judicial academies in almost every state, and all that the Supreme Court or the Chief Justice of the High Court has to do is to direct a mandatory session for the judges presiding in the commercial courts uh, before they assume their postings.
Yeah.
And just to add, I mean, our intent is not to belittle any particular small town or a district. I can assure you that in our experience, we have seen some of the finest judges
Yes.
coming from towns you
Yeah.
may not even have heard. The idea is that whether the knowledge is being percolated to them or not, whether they are abreast with the latest judicial precedents, are they being informed? Because it's also is sort of an incumbent duty on counsels like us that when we are presenting facts before them and when we are giving them judicial precedents, we must give them the entire picture.
Yeah.
Most of the times you have seen lawyers involved in sharp practices, they will just try to give a favorable decision, not disclosing what the other judicial precedents are. So, and if they themselves also have repository of judicial cases, now there are various platforms where you can access this information. I remember appearing before a district court in Gujarat, in Vapi, and the judge was having SCC online in front of him. Whatever case I was saying, he was looking through its summary, seeing whether it has been followed or not, whether there have been any changes which have been made, has there been any overruling of that decision that has happened. That kind of advancement in technology they should be coupled with or armed with at every point of time.
So the difficulty is that, I mean, just to add to supplement what Divyam said, that the problem is that you have a judge who was hearing matrimonial cases, or he was a sessions judge hearing bail matters and criminal trial, and he is posted in commercial court. He comes completely raw and unaware of commercial laws and various complications of the arbitration law. And so it's not to belittle the judge. The handicap is natural, and it is for the institution, the court as an institution, to ensure that is remedied, and to ensure that sufficient training is imparted, sufficient knowledge is imparted to such judges who take over responsibilities in commercial courts.
Also one mindset which needs to be changed. Uh, I have often faced judges saying, and when I press for an urgent protection or urgent relief, the judge said, "Oh, it's a commercial matter. We have matters involving life and liberty, so we cannot give precedent over. We are swamped with that work."
Right.
While I am not at once suggesting that those matters should not be given due importance, but we should not say that it's just commercial matters and therefore they can be put aside and maybe taken up at a later point of time.
Very, very interesting stuff we are hearing today. Let's move to the next question, which is around structuring of contracts. And the question is for Divyam, and it is a 2023 survey found that nearly 60% of cross-border disputes arise from poorly drafted contracts, nothing else. Can you believe that? When businesses enter into global agreements, how should they structure contracts to minimize the risk of disputes escalating?
Yeah, I may not agree with that statistics. I think it's more than almost 80 to 90% of the disputes are
Okay, it's
coming
worse,
out of,
you mean?
yeah, poorly drafted contracts. That's to an extent where our bread and butter lies. So now when you talk about when we advise clients, our go-to points are always, of course, first you need to have legal advice. I have seen sometimes clients becoming lawyers themselves and reviewing complex technical contracts without seeking legal advice. That unfortunately, as per me, is death nail of any contractual relationship. Second, the scope of work should be fleshed out properly. The risk allocation should be fleshed out properly. There should be performance parameters prescribed within the set of the contract. And closer to us, dispute resolution mechanism needs to be properly framed with a clarity whether there is going to be mediation, whether there's going to be arbitration, is it a two-step multi-tier negotiation, there is dispute advisory board, whatever is the framework, that framework needs to be spelt out clearly, and that framework needs to be ensured that it is as per the global acceptable practices. A lot of times our corporate partners who are dealing with clients on negotiations of very heavy contracts, they always come to us and discuss those issues like dispute resolution, limitation of liability, any risk in pertaining clauses, because they realize that we have that expertise, we understand that where it's likely to not be acceptable on a global platform, and those makes a lot of a difference. And I think IP rights, force majeure clauses, we have seen in COVID, force majeure clauses were really used by anyone and everyone. So these are some clauses which I would say you should be careful.
Force
while
majeure
drafting.
clauses just went through the roof after COVID and
Of course,
after the
of
war
course.
started, right?
Of course,
You
sir.
don't really know what force majeure to put in.
Yeah, and people have lost a huge contracts because their force majeure clause was not happily worded.
Very, very interesting. Okay, we move to the fifth question of the main framework here, and that is the new ADR mechanisms. And the question is for Amar. So, globally, mediation is being mainstreamed, which is a great thing, which is what you were mentioning earlier. So, the Singapore Convention on Mediation, it's a landmark. So, are we seeing new ADR mechanisms gain traction in India, particularly in high stakes sectors like infrastructure, energy, technology, things that are long gestation, very complicated sectors? Do you see an increase in that?
Mediation is actually an important form of dispute resolution in every jurisdiction, and it is no different in India. But culturally, Indians tend to prefer to litigate rather than mediate.
Really?
Yes. So mediation is not
It's
a
the
preferred.
wonderful insights you keep giving.
Yes. So this is from experience.
Yes, I
3
understand that.
decades and more. So the difficulty is that the challenge is that mediation is perceived as a non-binding, informal process, which is wasteful of time and cost. The fact is that it is not, and we need to promote advocacy of mediation. There is a legal framework for conducting mediation. Mediation is conducted professionally by qualified, trained mediators, and it is quite often successful, particularly in the disputes in the sectors that you just mentioned. Mediation is of key importance. The reason being that as a form of dispute resolution, it is less hostile. It is less acrimonious. It is more friendly. It is more informal. And in these sectors, because the participants and players in these sectors are very few, maintaining relationship is very important. If there are 5 players in a particular sector, you can't afford to fight with 2 of them. So preserving relationship is very important, and mediation, in fact, provides the best guarantee for preserving relationship. And it can also be cost efficient and time efficient, because provided the parties are honest and reasonable in their estimate and expectations. So reasonableness is of utmost importance for success of mediation.
That goes against the grain of the argumentative Indian,
Yes.
which is what you were saying earlier.
Yes.
Okay, we've had a phenomenal discussion. Let's now close this, but we have to do another round of rapid fire, and this time we'll keep it rapid. What is the biggest legal risk that businesses often ignore?
Enforcement of contract.
Judicial intervention.
One regulatory trend that everyone should watch.
Amendment to arbitration law and the insolvency and bankruptcy court.
I would say regulations on generative AI.
Most common mistake that clients make in dispute resolution.
poorly crafted dispute resolution clause and failure to provide for institutional arbitrations and designate established, reputed institution for conduct of arbitration.
Conflict between the governing law and the dispute resolution mechanism.
Let's say, in one word, your view of India's regulatory future.
Cautiously optimistic.
Okay, that's two words, but we'll take that. Yours?
Bright.
Fantastic. So, thank you very much, Amar, and thank you, Divyam, for sharing your insights. I'm sure you'll agree with me that it was a fantastic discussion, lots and lots and lots of insights, and it just goes to prove that, somehow Indians prefer litigation more to arbitration, which is unfortunate. But that's what it is like. And as we heard today, the strength of India's dispute resolution framework, it will play a defining role in sustaining investor trust and enabling cross-border commerce. Whether it is through faster arbitration, smarter contracts, stronger enforcement, resilience in dispute resolution is absolutely central to India's journey towards becoming a developed nation by 2047. So that is it for this episode of Season 2 of Transforming India, The Road to 2047, presented by Mint in partnership with JSA Advocates and Solicitors. I am your host, Alokesh Bhattacharyya. I'm signing off, and until next time, stay future ready, and please don't forget to say thanks to our two hotshot lawyers today.
Thank you.
Thank you very much.
Thank you.